Webinar today. I hope you all welcome everyone to our webinar today. I hope everyone has been having a wonderful summer, as even though it's hot, stay hydrated and so on. We have a lot of RSVPs today. We're sitting at 560, and I'm just as excited as you are to hear about the new laws and what's going on with the medical marijuana. So let's just get started right away with our introductions of our sponsors, starting with myself. I represent Beach and Patio Outdoor Living. We are 50 years in business, and we are full service doing selling furniture as well as repairing. So right now with budget season, a lot of people are looking at refurbishing, which means repainting or restrapping or reslinging your patio furniture to save money. If we can't do that, we have some great pricing, summer specials going on. We also sell cabanas, umbrellas, and beach chairs. If you need great pricing on that, some of this is in stock. We have overstock right now on a few lounge chairs and some umbrellas. So we are servicing every brand of umbrella from Tucci to Frankfurt. And if you want to make an appointment, call me. I'll get out there right away for you. And welcome again. With that, I'm going to go into introducing our first sponsor, which is Vinteum Software. We have today, Yasmin is on. And Yasmin is with the marketing department. She's my wind beneath the wings, the IT support, along with Layla Scola. So tell us about what does Vinteum do for associations?
Hi, everyone. Thank you so much, Peggy. My name is Yasmin. I'm the marketing manager here at Vinteum. Vinteum Software has been in the market for 10 years now. We operate across North America. We have two products, Neigbrs by Vinteum, which is a management and communication platform. It provides private portals and websites for HOAs and condo associations. And we also have Inspections by Vinteum, which is a solution for home and property inspections. It works on any device, you can use it from anywhere, and it works both online and offline. I leave our contact details in the chat box so you can reach out to us if you're interested to learn more about our solutions. Thank you.
Absolutely. Thank you. And thank you for all you do. Next, I want to introduce Diana Olert. She's the Director of Business Development for Best Roofing, and she's on the run. So tell us about yourself and what you do for the company.
Thank you, Peggy. Good afternoon, everyone. Thank you so much for being here today. I'm Diana Olert. I'm the Business Development Manager. I work with Best Roofing. Best Roofing covers Palm Beach, Broward, and Dade. And we do anything and everything that you need on the roofing, apart from like an inspection, repair, re-roof, recovery, maintenance programs, anything you name it. And just for being part of these class today, we're offering a free roof inspection for anyone who needs one to see where the roof states and what it needs to be done. So I'm going to be leaving my information on the chat box for you, and like, please don't hesitate to contact me. I'll be more than happy to help you.
Thank you, Diana. All right, next I want to introduce Dawn Miller, Director of Business Development, and she does a lot of marketing and events for the Paving Lady. Dawn, tell us about yourself and also about what the company is doing for associations.
Thank you, Peggy. Thank you, everyone, for being here today. I'm Dawn with the Paving Lady. We are an asphalt maintenance contractor. That means anything to do with your asphalt parking lots or roadways, seal coating, asphalt overlays, striping. We also do concrete sidewalks and curb. It's rainy season, so that means any repairs that need to be done need to be taken care of pretty quickly. Otherwise, you're going to have bigger issues down the road, pun intended. So I'll leave my information in the chat box. Have a great day and look forward to hearing from you. Thank you.
Thank you, Dawn. Okay, so I put another great representative, Beth Garcia Swopa. She's the Senior VP and an Association Specialist for Brown & Brown Insurance. Kind of ties into roofing. So Beth, tell us about yourself and Brown & Brown and what you do for associations.
Okay, hi, my name is Beth Garcia Swopa. I'm actually a 33-year agent in insurance. However, I've been with Brown & Brown for 13 years. As most of you know, we write more insurance for associations within the Florida region. That being said, some of you on here are probably insured with Brown & Brown already, so you're in great hands. If you are not, then I would encourage reaching out to us. As you know, all the issues that are taking place with insurance with respects to roofs, sidings, all of the new laws, feel free to reach out to me. I'll put my information on the contact, see how I can help you.
Sounds great. All right. Thank you for that. Next we had on the schedule was Kathy Dorn. She is not on today, but she is a vice president for Sun State Bank. They are also a full service association banking service. So if you need anything for that, I will be sending out a sponsor sheet and her contact information will be on there. Next we have Hafer Company. And this is a CPA service, which Nicole Johnson Pendergrass is a partner and also operations manager. Hafer is in many cities, about 5 cities all over South Florida, up to Orlando, over to Tampa. And if you need a great service for CPA or looking for somebody new, they do forensic work, please contact Nicole. Next, we have Munyon Painting, and Chris is not on today, but we do have, I believe, Erica. You want to tell us about yourself and the company?
Well, I work for Munyon Painting. So we are 72 years old, family owned and completely managed and ran that way. We do painting, roofing, and reconstruction. Anything that keeps the building together, we pretty much do, along with all the sidewalk grinding, patio pool deck painting or staining or anything you can think of. So that's about it. If you need anything, you can definitely call Chris Clark. He picks up his phone at any point in time of the day.
Great. He must be traveling. Well, thanks for filling in.
Yes.
And they do cover most of the state as well. So if you need some great painting proposals and services, please contact Munyon. With this, I'm going to introduce Erin Nickerson Foster. She is the Business Development Director, and she's with Rapid Response now. Erin, tell us about yourself and the company and what you're doing for associations.
Thank you, Peggy. That's the first time I've heard my new last name on a webinar before. Good morning, everyone. Thank you for joining us today. My name is Erin Nickerson Foster, and I'm with the Rapid Response Team. We are a statewide licensed general contractor that specializes in emergency services, including the topic of conversation today, odors that result from smoking pot, vapes, and cigarettes. We also can help diagnose and establish if somebody is doing that within your community with proven scientific testing, which you will need, and Steve will explain why you need those reports when he needs to do his portion of the job. We also specialize in water damage, fire, mold, and anything else that's on the interior of your building that does not belong there. We also provide free diagnostics for finding leaks, as well as providing continuing education to not only our property managers, like webinars like these, but also to the individual unit owners on what they're responsible for. If anybody has any other questions, I'll leave my information in the chat. And if you have a building with smoke, we'd love to come take a look at what you have going on.
Great, awesome, and congratulations again. All right, with that, we are going to clear the air. I'm going to turn this over to Katie Phillips. She's the Education Director and Marketing Specialist for Rosenbaum PLLC, who will introduce our outstanding speaker for today, Steve Brayton. Katie?
Thanks, Peggy. So I'm Katie Phillips. I am the Education Director at the firm Rosenbaum PLLC. We're a full-service law firm with offices in West Palm Beach and in Stewart. We handle everything from your smoking issues and all of your general legal counsel to contract review, document amendments, and even litigation collections. We do everything here in-house. Nothing is farmed out to anywhere else. I am the Education Director, and I have been in this industry on the manager side for 20 years and now with the firm a little bit over 5 years. And I'm also a state certified election monitor, so I do with the elections during the election season. And we can handle all of your needs. So today, Steve is going to be teaching the class. I have just a few little housekeeping things because there are a lot of people on here today. We are going to get your certificates out by the end of this week, and we will get the credits reported to the DBPR. We will also be sending all of the attendees today a copy of the presentation. I know that they are recording this and they will distribute the link, but only the managers that are in attendance today here in this class will get the credit for the class. Please allow 3 to 5 business days. The DBPR has been a little slower on the bulk uploads. So if you don't see that by like maybe the end of next week, then you can reach out to me and let me know. And thank you so much for having that. So with that, I'm going to turn it over to Steve to introduce himself and we can start the presentation. Thanks.
Thanks, Katie. Good afternoon, everybody. My name is Steve Brayton. I'm a shareholder with the Rosenbaum Law Firm, and I oversee the the association practice group. I've been practicing in Florida now going on 30 years, primarily representing planned unit developments, community associations. And for part of my practice, I was in-house counsel for a major real estate developer on the west coast of Florida. So I've been on all sides of things. And, should you need any advice for your community association, feel free to reach out to us. Today, we're going to be talking about a hot topic, marijuana, in particular medical marijuana, and what your community association can and cannot do when you receive a complaint from an owner regarding smoking. And this is particularly prevalent in close proximity, high-rise condominiums, mid-rise condominiums, and multifamily dwellings. So we're going to talk about that. And we're also going to talk about some of the most recent changes in the law and things that are brewing and that are, coming as we move into 2024 and what we can expect to see in the legislature and possibly some proposed constitutional amendments, which may have a significant impact on this whole topic. So with that, let me just get the presentation on the screen here. And can everybody see that? Perfect. Okay. So let's get started here. How do I get rid of this bar up here? Perfect. Thanks. Okay. So, this is certainly a complicated area in the law. It's a developing area. In fact, this morning I just took a quick look to see what are some of the most recent cases that are brewing out there in marijuana land. And most of the cases, there aren't very many, number one. And number two, most of the cases deal with employees being terminated by their employer after being tested positive for marijuana, and the employee has received a medicinal marijuana card, meaning they've been authorized to use marijuana for medicinal purposes, and their employer has terminated that person, and they're suing for discrimination. Okay, and we'll talk about how those cases are coming out. But just by way of background, Florida first legalized medical marijuana in 2014. There was an amendment to the Florida Constitution after that that allowed for full potency cannabis for patients with terminal medical conditions. And then subsequent to that, a referendum was passed that expanded the original definition of debilitating medical condition and allowed for expanded use or prescription of medical cannabis or CBD, containing full strength medical benefits to covered individuals. Now, interestingly enough, when these laws, it's been 6 to 7 years since these medical marijuana was made legal in Florida. However, it wasn't until last year that the Florida Department of Health actually set limits on what people can use and prescribe. So it took 6 years for the Florida Department of Health to get around to that. And then when they did it by emergency rule, meaning that there was no comment from the public, whether it was from medical providers, citizens who were users because they're being diagnosed with a medical condition that meets the statutory definition. So all this happened last year. And the rule basically set out supply limits for different routes of administration and calculated, doses that were permissible. So under the rule, Patients' daily THC doses are restricted to 60 milligrams for edibles, 350 milligrams for vaporization, 200 milligrams for capsules and tinctures, 190 milligrams for sublingual tinctures, 190 milligrams for suppositories, and 150 milligrams for topicals. So that's was done last year. And we also have a new commissioner for the Florida Department of Agriculture and Consumer Services as of last year, which issues licenses to facilities who can distribute medical marijuana and other authorized products in the state of Florida. So there's certainly been a change in Florida in terms of you know, the political posture with regard to this topic. One of the most recent developments, which will be coming in 2024, is a potential proposed amendment to the Florida Constitution authorizing recreational marijuana. And that's been challenged by the Attorney General, Ashley Moody, and that's being fought right now in the Florida Supreme Court. There was a press release just this last Friday detailing the dispute. The Attorney General is essentially targeting the largest supplier in the state of Florida as having contributed most of the money to push the ballot, you know, the proposed amendment onto the 2024 ballot, which is True Leave. And that's being done through a political action committee called Smart and Safe Florida. So this is something to keep an eye on, because this is something that may end up on the ballot in 24 for Florida to vote on whether to authorize recreational marijuana, which would be a potential, you know, game changer for us if it gets to the Florida Constitution. One thing to bear in mind as we talk about this topic and where the issue really gets complicated is that under federal law, marijuana is still considered a Schedule I drug under the Controlled Substance Act. And so while under state law, medical marijuana has been authorized, if you're found in possession of marijuana, you're still potentially subject to prosecution. Now, I don't believe local governments are necessarily prosecuting those, but, you know, on a federal level, you're still subject to prosecution. And that's one of the issues that Attorney General Moody has raised in her opposition to this proposed ballot amendment for recreational marijuana, because it is still considered a Schedule I drug under federal law. And so it's going to certainly get interesting as things develop. Some other changes that have occurred recently. Governor DeSantis signed a measure in the last legislative session in 2023, allowing telehealth option for medical marijuana renewals. So while you need to have an in-person exam in order to initially qualify for a medical marijuana card, subsequent renewal will be allowed by telehealth. Okay, so that was one of the most recent changes that happened. Another proposal that we could see on the ballot for a constitutional amendment is one that's being proposed to allow adults who have already received approval for medical marijuana to grow marijuana on their own property, as well as for patient caregivers to grow cannabis on their own property. So that's something that's also being pushed for the 2024 ballot. Another item that came up was tightening the regulation of hemp products and making sure to curb access by minors. So that was recently approved by the Florida legislature. And that, for people's reference, was Senate Bill 1676. So if you look that up on the Florida website for laws of Florida, and you reference Senate Bill 1676, you'll find some changes that were made to tighten up the sale of hemp and to make sure that the euphoric strains don't make it into the hands of minors. Okay. So
Dave, can I add something? Excuse me.
Sure.
I forgot to mention to all those who have a question, you can put your questions in the Q&A box, and Katie is our moderator for today. She will interject them as Steve goes along, or wait till the end for your questions to be addressed. All right, thank you.
Absolutely. Thank you, Peggy. Appreciate that. So I'm not going to spend too much time on how you go about getting approved for medical marijuana use. Our presentation goes through that in detail. I'll just summarize by saying the Office of Medical Marijuana Use regulates issuing these cards, and there's an entire process that you have to go through in order to qualify. The Florida statute set forth the type of medical conditions, excuse me, that do qualify. And you can see that list on the screen. Post-traumatic stress disorder is one of them. And that recently actually came up in a case that was just decided by Florida's appellate court last month. A state corrections officer who was diagnosed with PTSD and who did receive a medical marijuana card and was using medical marijuana to treat his diagnosed condition, was terminated from his employment by the state correction facility. And that employee brought an action against the Florida Department of Corrections for wrongful termination and discrimination. And the First District Court of Appeal held that because marijuana is still considered a controlled substance under the Controlled Substance Act, and that this individual has to carry a firearm as part of his employment, which violates another federal law, meaning if you're in possession of marijuana and a firearm, that's a violation of federal law. So the appellate court upheld the employee's termination, and that's on rehearing right now and is likely to go to the Florida Supreme Court. So again, this kind of illustrates the intersection between, okay, under state law, we have these permissible exceptions, medical marijuana for the time being, maybe recreational marijuana in the future, and the federal law, which still considers marijuana to be a Schedule I controlled substance and a violation of federal law. And how do we manage these things, and how does that affect associations when they have to deal with complaints over somebody using marijuana in their unit? Okay, so I'm going to bypass this part of it and just we've talked already about recreational use in marijuana, and in Florida is still illegal. However, that could change next year depending on what happens. This talks about the decriminalization of marijuana over time in Florida, and certain counties that have further decriminalized marijuana possession up to 20 grams. There's a great website out there if you want to see. Let me just get to that slide.
We'll send a copy of the link.
Yeah.
Yeah.
So right now, from a state by state perspective, 38 states, 3 territories, and the District of Columbia have all passed laws that have authorized medicinal use of marijuana. We're going to send out a link that will give you a picture of the United States and show you by state, what they've done in terms of medical, recreational, both, what have you. And then from there, you can go to each state and see the laws in each state. So it's a very helpful website. Okay. Now, as we talked about briefly already, if an employer has a drug-free workplace, the employer still has the right to terminate an employee for use of marijuana, even if they have, authorization from the state to use medicinal marijuana. There was an effort to pass a Employee Protection Act, which failed a couple of times. They tried it, I think, in 2020, and then they tried again last year. And so as an employer, if you have a drug-free workplace, you have no obligation to permit somebody with a medical marijuana card to use marijuana while on the job. So, and I should mention, by the way, with the correction officer, the state offered him the opportunity to come back to work 30 days after ceasing use of marijuana. And apparently that corrections officer declined that opportunity. And so that's how that case unfolded there. As we've talked about, employees are not required to report that they use marijuana unless they have already disclosed that they have a qualifying health condition. Again, the problem you run into here is the Americans with Disability Act is not going to provide somebody with protection who has been afforded a state medical marijuana card, because the Americans with Disability Act is a federal statute, and the federal statute does not provide an exemption for use of marijuana because of the Controlled Substance Act. So the Controlled Substance Act controls, and there's no exception under the ADA as yet for use of marijuana. Okay.
So Steve, I think this is a good question. So
Sure.
is medical marijuana including smoking marijuana, or is it in, a liquid form? And if that is the case, that they can smoke it as part of the medical, can that be limited to certain?
Well, so in terms, the ability to smoke it for medicinal purposes has been limited by virtue of this rule that came out last year from the Florida Department of Health in terms of how much you can have in a given period of time. So they set a limit on the supply that can be prescribed by physicians, which is why a lot of physicians were up in arms that the state agency issued the rule under their emergency powers rather than taking comment from the public. So they just, from the medical establishment's point of view, surreptitiously came up with these guidelines or these mandatory, so not really guidelines, but mandatory prescribing dosing limits. So, the real issue becomes is, for an association is if somebody has been given a medical marijuana card and they have the right under state law to use marijuana to treat their medical condition, which they've been diagnosed with, does the association have no right to limit or preclude that owner from smoking in their unit? Okay, and so that gets into how does that interfere with other owners' right to use their unit, and how do you best go about regulating that? So we're going to get into that in a little bit here. So we've talked about the whole employee thing and an employer's right to terminate an employee. Now, on the other hand, if an employer doesn't want to do that, they have the right to permit it. It just is a function of what is the employer's policy with respect to drug use. Certainly with regard to public employers such as counties, cities, and the state, if they're a drug-free workplace, what we're seeing in the case law thus far is they have a right to terminate that employee without any type of liability for discrimination. So when we talk about what a person may do, Katie, on private property, a patient may smoke or vape medical marijuana on private property as allowed by the property owner. So that, gets into who's the property owner. And so in a community association standpoint, particularly in condominiums and co-ops where you're in a building setting or townhomes, if you're an HOA and you have, multifamily structure, what right does the association have to regulate the use of this on common property, limited common elements such as balconies, by the swimming pool and the clubhouse, outside of the building, in the lobby, all of these different areas become an issue, right? So this is something that is becoming increasingly a problem for associations that we represent, particularly in older buildings where the ventilation systems were designed such that, if somebody's, you can smell the downstairs person, cooking a meal in their house and it coming up through the ventilation system. Certainly smoke is going to be also coming up. And the biggest complaints we hear are the odor. And once they smell it's marijuana, that triggers, other issues and concerns. And, smoking in general, whether it's marijuana or any type of smoke, has become a problem for a lot of community associations. So What we recommend is, number one, if you have the authority in your governing documents to adopt rules and regulations regarding, the common areas and the limited common areas, then the association can adopt a rule prohibiting smoking of any kind in those areas. Your association can designate a location or locations on the property where it's acceptable to smoke. And then, of course, we get into, can we regulate an owner's right to smoke in their unit? And that becomes more complicated, because if we're going to restrict an owner's right to do something in their unit, typically that's going to have to be done by an amendment that your membership is going to have to vote on. And the likelihood of the success of that type of an amendment is going to depend on a lot of factors, including how many votes do you need to amend your documents, whether it's a majority or some super majority amount, such as 2/3 or 75%. So those are things that your community are going to have to look at on a case-by-case basis. You're going to have to decide as an association and as a board first, do we want to be a no smoking building or a no smoking association, property, and, then consult your association attorney to figure out how to get to that end goal. Now, when you do get complaints about, smoking complaints, whether it's marijuana or any other type of smoking complaint, it's going to need to be documented in writing. A lot of folks are willing to make a verbal complaint, but they're not willing to put it in writing, which, can be problematic. Certainly management can send a violation letter. If you have if you have a nuisance provision in your governing documents and somebody's complaining it's causing a nuisance, I can tell you this, that, a generic nuisance provision is not as strong as having specific rules and regulations with respect to smoking. While you might not, as an association, be able to prohibit smoking in a unit, the association can establish certain protocols that owners have to follow in order to minimize smoke escaping from their unit, including, certain air conditioning filters that are designed specifically for that purpose, as well as other remediation or preventative techniques that can be employed to minimize smoke from escaping from one unit to the next. Okay, so these are things that you may be able to do by rule as a board, as opposed to an amendment to your governing documents. The division of arbitration that governs condominiums and co-ops, I can tell you with these cases, as Aaron alluded to earlier, you're going to need to have expert testimony to substantiate your claim that there's smoke coming from the unit and interfering with another unit owner's ability to use and enjoy their unit, essentially creating a nuisance or violating some other rule that you've established. Or if in the case of a no smoking ban in your governing documents, such as your declaration of condominium, you're still going to need some type of expert objective report and testimony to confirm that whatever is happening is actually happening. Otherwise, you're probably going to be on the losing end of that case. And whoever's complaining, they're going to need to be willing to testify before either an arbitrator or a judge in court in order for the association to meet their burden to win that type of case. And so those are the kind of things you want to look at up front and make sure that the people who are complaining are willing to see things through. Because as an attorney, once I get into it, the most common problem we run into is a lack of evidence, to get over the finish line and, obtain relief for the association. And, these cases are attorney fee cases, meaning you bring this kind of case and lose, you're going to be paying the other side's attorney's fees and costs to defend the action if they hire a lawyer. So keep that in mind. So as we talked about briefly, it's important for the associations to keep a report that includes information, essentially a diary, date, time, name of the parties involved, what was expressed, what concerns were expressed, and you're going to have to build a record. This is not something that's going to be solved quickly, certainly not in days. It's going to take a bit of time to build a case where you're going to be able to get to a point where you can successfully prohibit somebody from smoking. Now, if you have a rule, for example, as the picture illustrates, somebody on the balcony is smoking, and that's something you can document with a photograph, and you see that happening over and over again, then that's a simpler case than the case where somebody's smoking in the unit and you're trying to stop them from smoking in the unit because it's interfering with other owners. It's getting in the hallways. People, can smell it in the elevators, things like that. If it's coming from a unit, that becomes the harder case. Okay. So as we talked about briefly, we need to establish policies regulating the use of medical marijuana or any other type of smoke. I prefer to keep these policies neutral and not necessarily target, one type of smoke versus another. But, if the marijuana is the biggest concern, you can certainly, have a policy specific to that. Now, what hasn't really been addressed yet, and I haven't seen any cases on this, is where just like in the emotional support animal land, when somebody comes in and says, well, look, I have a diagnosed medical condition. I have a medical marijuana card, and I understand you've adopted this rule that prohibits or limits or whatever the case may be, but I want the association to make a reasonable accommodation under the Fair Housing Act and waive that restriction as it applies to me because of my diagnosed medical condition. So here's where the laws intersect, because under the Federal Fair Housing Act, the cases say you're not entitled to that type of an accommodation. Why? Because marijuana, again, is still illegal under the United States Controlled Substance Act. So if I don't have to provide the accommodation under federal law, why should I have to provide it under state law? Because Florida has its own version of the Fair Housing Act. And, that becomes an interesting question. I don't know the answer to that. I haven't seen an appellate case in the state of Florida to address a claim where a unit owner brought a claim against an association for failing to grant that accommodation to allow medical marijuana to be used in a scenario where it was otherwise prohibited by the governing documents. And the association argued, we're not obligated to provide that accommodation because federal law still has marijuana as a controlled substance, even though it's permissible under state law. So that really is the question that needs to be answered.
So Steve, there's a lot of questions
I
coming
bet.
in. I know we've covered some of this stuff,
Yeah.
but one of them, I've had multiple questions.
Yeah,
What
sure.
if someone is like a seasonal resident and they have this license from another state? Do they need to
Yeah.
get a Florida license as well?
Okay, so that's interesting. So I would think that they would need to get, the question here is if somebody has a medical marijuana card from another state, does that allow them to use marijuana in the state of Florida? And my initial response is no. I don't know that there's what we call, like we're giving what's called under the Constitution, full faith and credit, or we're recognizing another state law in this state. So I would think they would need to have a card issued in the state of Florida in order to use it in the state of Florida.
Awesome.
Yeah.
And for just like with regular cigarettes, right?
Right.
So can the board put the same restrictions on marijuana since
Right.
it's medical for common areas and pool areas and things like that?
Yeah. So again, the question is can we regulate the use of medical marijuana in common areas because it is medicinal and under state law, they're allowed to have it. This question again gets into, do I have to grant somebody an accommodation where I have a no smoking, let's say I just have a generic no smoking rule on any of the common areas of the condominium or property. And they come back and say, well, I have, a state issued medical marijuana card. I've been granted permission to do that. I think my gut tells me the answer is the association can still regulate that and still has the right to protect the health, safety, and welfare of the residents of the building, which is the purpose for the association's existence under state law in the first place. And that if the person wants to use their medicinal marijuana, they would be limited to doing so in their unit. short of an absolute ban of smoking of any kind on the property. So I think those rules and regulations would stand legal scrutiny, but as I said before, I don't have any case law that I can point to yet that supports my, my gut feeling on the issue. Yeah.
Got it.
What
Go ahead.
else you
Well,
got? Okay.
we have lots, so
Okay.
we'll just different ones and
Sure.
we'll get back to some of those.
Yeah.
I think, I have another one. Can you ask to see the owner's medical card?
Yeah, I think the question is can you ask the owner to provide you a copy of the state issued medical marijuana card? I think the answer to that is yes, because that card isn't going to contain a medical diagnosis or, private medical information. You're not asking for medical records, but rather you're asking the owner to substantiate they actually have been granted the right to use medicinal grade marijuana. So I don't see an issue with that. Once you do have a copy of that, I think that would be something that would fall into the category of a protected or confidential record that wouldn't be subject to official record inspections like other personal information of a unit owner that's protected by statute. So yeah, that's where I land on that one.
Awesome.
Okay. So this gets into, can I grow my own marijuana? So as I mentioned
Your
before,
balcony flower
yeah,
box.
yeah. So yeah, right on the balcony, it's perfectly fine. No, so right now the answer to that is no, you can't. But as I mentioned earlier, there is a push to put on the ballot for 2024 at least individuals who have received a medical marijuana card or their caregiver the right to grow marijuana on their property. So the answer to the question right now is no, but stay tuned. It could change. And again, the real question becomes, in all this discussion is the federal government gonna change their position and remove marijuana from the Controlled Substance Act? That would take an act of Congress, and whether they remove it entirely and open the door to possession of what would be considered recreational marijuana, or come to some federal law that permits medicinal marijuana. That's an interesting topic, and I'm not sure where that's headed, but certainly there's been a lot of money and a lot of money invested in all this. So I would expect there to be a change in the Controlled Substance Act in the next, 3 to 5 years would be my prediction. So if not sooner. I'm gonna get, let's see what else I might have missed.
We
Here.
have some more employer questions. I know
Okay.
we kind of breezed through that.
Yeah.
But so if you have if association is hiring as a drug-free workplace,
Right.
and obviously you can make the restrictions that they can't smoke while they're on the job, but can
Right.
you still deny them if they fail a drug test with marijuana, but they have a card?
Yeah, so I think the answer right now in the state of Florida is yes, an employer, if you're an association and you're the employer, and you have a drug-free workplace policy that you're enforcing consistently, and doing random drug testing of your employees as is required, then I think if the association does have the right to terminate the employee for drug use, even though they may have a medical marijuana card, and have the right to use medicinal marijuana. So that seemed, until the state of Florida passes that law that they've been trying to pass, providing employees immunity, then the answer right now is private employers still have the right to terminate somebody for drug use, even if it's medical marijuana.
Awesome.
Yeah, yes.
Just to interject, you have until 1:30 because I always add extra time because of the introductions that take away. So.
Okay, very good. So I can get into some of these other slides we might have
Yeah.
skipped over. So
Well, and we do have a lot of questions. They're kind of a lot of the stuff that you have covered and some other stuff that has not necessarily been covered. But I think really one of the biggest questions is coming down to what can the board do about smoking. I mean, really, honestly, I don't think anybody cares if you go take gummies in your whatever, but the smoking of marijuana.
Right. So the issue really, as Katie said, is boiling down to is the smoking versus these non-offensive other treatments that are available to people who have a medical marijuana card, such as edibles or oils. You know, at the end of the day, when it comes down to smoking, as I said, the association, so long as it has the right to regulate common elements and limited common elements and the use of the condominium property, then the board can adopt rules that prohibit smoking in common areas. And if you're going to attempt to prohibit smoking in units, you're going to have to amend your governing documents, particularly your declaration of condominium or covenants and restrictions if you're an HOA, and this is an issue for your community, and you're going to need a membership vote. So that's a membership meeting, and an amendment that's circulated proposing to ban smoking in units. At which point, once that amendment is passed, assuming it's passed, then you're in the position of now you've got to enforce that. And what does enforcement look like? That looks like you have to file some type of action, whether it's with the Division of Arbitration in Tallahassee or in a state court, seeking an injunction that is going to prohibit the owner from smoking in the unit. And so you're going to have to prove your case by a preponderance of the evidence that the smoking is taking place in the unit in violation of the governing documents. If we don't have that kind of an amendment in place banning smoking, then you're forced to rely upon what is typically in the governing documents, which is a generic nuisance provision. And when I'm relying on a generic nuisance provision, that's going to be a lot harder, because that becomes, you know, I need testimony from neighboring owners who are willing to come to court, who are willing to sit for a deposition and say that their lives are being interfered with when they're in their homes because of the next door neighbor who is smoking, whatever that smoke may be. So, you know, to Aaron's point at the beginning, I'm going to need an expert. I'm going to need some air quality testing. I'm going to need some kind of expert testimony to validate what's happening, and that it's at levels that would be considered sufficient to cause a disturbance, because what bothers one person may not bother another person. And, you know, when we're restricting somebody's real property rights, because that's what we're doing here, even if I'm in a condominium unit or a co-op, that's still my real property rights. And so if a court is going to restrict that person's real property rights, there's going to need to be sufficient evidence to warrant that type of injunction. So, you know, that's my view on the topic, and other lawyers may have a different view, but I think that's how it's gonna play out. So let me back up a little bit to
and not just marijuana, but any smoking in a unit. And we've had this come up with our clients. I know that if it's causing a nuisance or somebody can smell it through the wall.
Right. Yeah. I mean,
any smoking, not just marijuana.
It can be any smoking. I mean, we've had people complain that their clothes reek of smoke from in their closets. Again, all of this, having these complaints given to management or to the board are fine. But as we've talked about, they need to be documented in writing. They need to be, and these folks are going to need to be prepared to see the process through. So it needs to really be explained to them up front that their cooperation and participation is going to be needed. And then also, let's not forget the fact that an owner has the right to sue their neighbor. Okay, so it doesn't always have to fall on the association. The reason why typically the complaints are to the association is why? Because it costs money to hire an attorney to sue somebody. So they'd rather the association do it than the owner take the matter into their own hands. So, you know, if at a certain point we can't, as an association, develop the necessary evidence to bring a case within your lawyer's in your lawyer's opinion that you have a likelihood, a reasonable likelihood of success, you know, then the answer to the owner who's complaining needs to be, this is something you can take on your own. It's not like the owner doesn't have any rights. So, you know, let's not lose sight of that fact. But going back to the employer issue, as we talked about briefly, you know, this is something that has been coming up over and over again in the legislature since medical marijuana has been permitted, and they've been trying to pass, or at least certain legislatures reps and senators have been trying to pass a medical marijuana Employee Protection Act. It was attempted again. I know it was attempted in 22. It may have been attempted in 23 again, and hasn't been successful. So if something like this were to pass, which hasn't yet, then it would prohibit an employer from taking adverse action against an employee who's using medical cannabis. So I would suspect that that's something that's going to happen at some point. But until that happens, employers, including associations, are permitted to, have a drug-free workplace. And even if somebody has a medical marijuana card, take adverse employment action against that employee. And as we saw in this recent case involving a state correction officer, where the issue there was he was in violation of federal law, the state was within their rights to terminate that employee.
And how about if the employee has a medical card and they actively do use marijuana products and they're injured on the job? Will the association have an issue with workers' comp or with the insurance?
That's a great question. So the issue is so if I have somebody on the property that is using medical marijuana and they're injured during working hours, will there be coverage under the workers' compensation policy that the association has for their employees? And a lot of workers' compensation carriers require a drug-free workplace in order to issue the policy. And so it's very possible that you may not have coverage in that scenario. And that's something that you would need to talk to, an insurance agent such as, Brown & Brown, who we have here today, so that they can give you some indication of what your policy exclusions look like as an employer. And that could really, answer the question right there. And, when the state looks to exempt, provide some protection to employees, they're going to have to deal with this insurance question at the same time, because it would kind of be self-defeating to leave the employers exposed for a workplace injury, but yet require employees to be allowed to use medical marijuana at the risk of injury on the job. And, certainly it's an issue when driving, because if you're under the influence when driving, even though it's medical marijuana, and you cause an automobile accident, you may not have auto coverage to cover you for that bodily injury or property damage that you cause in that scenario as the at-fault party. So again, there's a lot of issues that haven't been I'm not going to necessarily say thought through, but that need to be addressed in order to make all of this work in a way that makes sense. While at the same time, we understand that the industry is pushing this because, anytime money is involved, the profits are what are the motivating factor, as opposed to these other practical problems that we run into.
But I don't think that you can actually tell people they have to use other than smoke, that you can't say you have to use liquid or gummies or something else. You can't smoke.
The issue,
you can offer
yeah,
as an option, but
right. Yeah. I mean, the issue there is if we're talking about, a drug-free workplace and, the drug test comes back positive, doesn't matter what they were using, but
Yeah.
certainly you can prohibit smoking as an employer. You can prohibit smoking on the employment premises, regardless of what type of smoke it may be.
and prohibit them from testing positive.
Right,
'Cause you can,
yeah.
right, yeah.
Yeah,
so-
absolutely.
Yeah.
Yeah. So,
There's also a couple questions about renters, how to deal with renters. Is the
Okay.
owner responsible for their renters? How do we?
yeah.
do
So
that?
when we're dealing with renters in an association setting, the owner is always responsible for the tenant's conduct. So if the tenant is the one engaging in the offensive behavior, you still have to point to a violation of the governing documents, whether it's your declaration, bylaws, rules and regulations, in order to trigger some type of responsibility for the owner. So then the question is okay, so the tenant is violating some rule prohibiting smoking, whether it's marijuana or any type of smoke, and who do I direct that violation notice to? Well, we typically do it to the owner and the tenant. And at a certain point, demand can be made that the owner evict the tenant for violating the governing documents of the association. Otherwise, the association is going to take the legal action and attempt to hold the owner responsible for the attorney's fees and costs incurred in the legal proceeding if it's the prevailing party for the violation. And that's, again, to receive your attorney's fees and costs back from pursuing a legal action, wherever the forum is, arbitration, state court, we have to be the prevailing party. So that's why that evidence up front becomes very important, because you're going to put a lot of money into that case and you want some reasonable likelihood of success. You can never have a guarantee of an outcome, because obviously you have other people making these decisions. You never know what a judge or jury may do. But you certainly want to have things lined up going into something like that. So
You mentioned at the beginning of the presentation about a qualified experts. Who were those people?
So somebody that is licensed to perform air quality assessment. So you have indoor air quality assessors. Folks that may do mold assessment may also be qualified to assess indoor air quality and perform that type of an assessment. I know that Erin said her company is qualified to or have people on staff that are qualified to perform those assessments. And, we certainly have other people that we've dealt with that have the appropriate licensing, but they should be licensed by the state of Florida to perform some type of indoor quality assessment.
Yeah, which leads me to the next question. Does the association have authorization to enter the unit to do that testing if the owner is not wanting to give them permission to do that?
So that's a great question. So does the association have the right to enter a unit to test for smoke if the owner is refusing to provide that access? And so, at least when we're looking at
get creative, and
yeah,
so we need to check your dryer.
The Florida Condominium Act, if we're talking about condos, is very specific in terms of right of access to a unit. And while that right of access is referred to as irrevocable, meaning it's an ongoing right of access, it has to be related. The purpose of the inspection has to be in connection with the maintenance, repair and replacement of the common elements of the components of the unit that the association is responsible to maintain, repair and replace. So, one position could be, look, if there's excessive smoke in the unit and it's permeating through the drywall and entering other units, then you might have a basis to demand entry. But now we're fighting another battle, right? Now we're first trying to vindicate our right to get into the unit, to first do the air quality test, to bring the case against the owner. So, these are examples of the problems that you run into on a practical basis. So, testing is probably going to have to be done in units surrounding the unit of the owner who's the culpable party, in the hallway, and from various different locations. Because at the end of the day, if it's truly bothering, the next door neighbor, then the expert should be able to detect that from that unit. And if they can't, then, I would suggest that you have a problem with proving your case against the alleged wrongdoer. So.
Thank you.
Yep.
And this is another good one. Hold on. There's a lot of different questions, but I'm just trying to, we can only give, very basic general legal advice. And this is such a newer area. I think it's important to say that if you have issues, you should talk to your counsel.
No question. I mean, this is probably one of those areas of law that's changing at one of the most rapid paces. And, you can go on the internet on any given day and you may find some new development, such as these bills, these proposed amendments to the Florida Constitution that are percolating, the legal challenges that are being brought, new cases that are being decided. So this is changing literally, day to day. So.
This is a good question. So if the board does decide to make some document amendments to restrict smoking, including marijuana smoke, and an owner votes no, like some of the other restrictions, are they then exempt from the change, or since it is a use change, or is?
Right. So the question is if, an amendment is passed to the declaration of your association and a particular owner voted no, is that use change, that use restriction going to apply to the owner who voted no? So by way of example, in the Florida Condominium Act, when we adopt certain, the Florida legislature has identified certain exceptions where even if there is an amendment governing, for example, lease restrictions, durational restrictions, such as the amount of time I can lease my unit. So if your declaration of condominium used to allow rentals for 3 months, and now you've changed it to minimum rental is 12 months, or you've imposed a wait period on renting that may impact an existing owner as opposed to a new buyer, the Condominium Act says those type of lease restrictions are not going to apply to owners who have voted no, and the older provision is still going to govern that owner. So there aren't any exceptions built into the Condominium Act with regard to smoking. So I would say that even if somebody voted no, that the amendment, if properly passed, is going to apply to that owner. And the Florida Supreme Court has held that people who live in planned unit developments such as condominiums, co-ops, HOAs, they understand their declaration can be amended by a membership vote. And as long as that threshold is met, that amendment is going to generally govern that owner, even if they voted no. So unless it falls into a very specific exception under the statute, and Chapter 720 has its own specific, durational exceptions to changes in your documents, but the smoking hasn't been one of those that have been identified.
Well, and I think that there's also limited case law, as you said so far.
Yeah.
So like as far as fair housing complaints and things, because they do have a medical card.
Yeah.
That hasn't reached appellate level.
Yeah,
yet.
that to me is really what we need to see, is what are the state courts going to do when somebody challenges a declaration of condominium that bans smoking, and they claim, well, I have a medical marijuana card that's permissible under state law, and I should be granted an exception to the no smoking in the unit because of that medical marijuana card issued under state law, when I still have federal law saying that possession of marijuana is illegal. That to me is the case that we need to see, at least in Florida. And there may be cases that have been decided in other states, but I haven't seen those yet.
And hold on one second, I had a couple of other questions here.
So while Katie's looking at the questions, one of the things I didn't get into.
Can you send violation letters for this, and can it go to a fining situation?
Violation letters for the smoking?
For the smoking.
Yeah, I mean, if you have a properly adopted rule, regulation, or document amendment that depending on where the smoking is happening. So as I said before, for rulemaking, it would have to be outside of the unit, and a document amendment for inside the unit. The question is then, can we send a violation letter and fine the person? If you have adopted the rule correctly and you're enforcing it uniformly, yes, then the answer would be, I think you could send the violation letter and ultimately engage in fining. But at the end of the day, when you're dealing with somebody like this, I equate this to, the same thing as somebody who has an emotional support animal that you may think is not a legitimate emotional support animal. They're not giving up that dog that easily. And they're certainly, if they're smoking, they're not giving up that smoking. So I'm not sure going through the fining process is going to get you where you want to be, which is to stop the behavior. So really, I think in this particular scenario, you're looking, you certainly got to put the person on notice of the violation. I'm not sure, my point is, I'm not sure how effective fining is going to be in this situation. So,
can you restrict marijuana smoking, but still allow cigarette smoking in certain areas? I mean, I think probably you don't want to.
So the question is can we allow cigarette smoking in certain areas, but restrict marijuana smoking in the other areas? I think that would be a problem, particularly where the person has the medical marijuana card. Now you're really, taking it a step further, because what's the I understand, you say, well, it's marijuana, but the threat to the health, safety, and welfare, arguably isn't significantly different, to the residents, because, cigarette smoking and the literature on secondhand smoke and the carcinogenic effect of of regular cigarette smoking is just as prevalent. So I wouldn't necessarily go that way. That's my personal take on it. You know, somebody else may have a different opinion. So.
And if a complaining owner has air tested in their own unit with good quality results, are they responsible to pay for it? Should the association pay for it? And, you know, if they present that there is an issue, will the association have to do something? And does the neighboring unit have to pay for the remediation? I know that's a lot.
Yeah. So, you know, the question is who has to pay for what, depending on what the outcome of the testing is. And I think that, if, you know, a unit owner is complaining to the association of a nuisance problem based on smoke, regardless of whether we're talking about marijuana smoke or any other type of smoke, that the initial testing costs are going to be on the association's dime, if you will. And that depending on the results of that testing, if there is a problem, you know, the report is going to be the evidence that we rely on and the person who did the testing. Ultimately, I think you wouldn't get those costs back unless you actually brought a lawsuit and was successful in that lawsuit. Otherwise, I think that's going to be at the association's expense. You know, the owner who's complaining, you know, the association could take the position, I guess, that, you know, have the owner who's complaining incur the expense up front and hire that person. But, you know, we may not know whether they hire a qualified person. So the value of that information may or may not be good. So it just really depends.
Yes, and who does the testing? That Aaron mentioned their company does. A lot of
Right.
the remediation
A
companies.
lot of remediation companies do it. I think mold assessors are also indoor air quality. So you're really looking for an indoor air quality specialist who's licensed in the state of Florida to do those types of assessments.
Okay, and I think that comes to a conclusion. I know some of you, I didn't get your questions, but they're very specific and we can't give specific legal advice. So I do advise you, if you have some specific scenarios, to talk to your own association's attorney.
Yeah, if you have a very, you know, fact-driven problem, then you're going to need to reach out to your association counsel to run that scenario by them. You know, these are just broad topic discussions, and we can't give any specific legal advice to any one particular association. So,
And thank you guys all again for attending. Peggy, I'll turn it back over to you.
Okay. All right, great.
Very good.
Great information, Steve. Thank you so much. And Katie,
my
too.
problem. My pleasure.
Yes, absolutely. Our pleasure. So I want to close with a couple things. First of all, I just want to make a reminder that this is recorded. However, no one can receive a CAM credit from just the recording. So only being on the call today will give a CAM credit. Also, I want to remind you that there will be a sponsor sheet coming out along with the link for the recording from today. We'll have everyone that sponsored today, sponsor information, contact information, and please contact them because it is budget season and maybe they can help you with something. There's some upcoming webinars to note. Next week on August 15th, I see where Katie at Rosenbaum is having another webinar, and it's going to be all about assistance animals with another attorney, Palomara. On August 16th, I have another one coming from DSS Condo. It's a new class, new CEUs on planning projects. This is going to be great with Michael Powell and Heidi Koto. And then on August 22nd, we have a tentative Orlando topic to be announced, but that is also coming. It's probably going to be on insurance, I believe. But thank you all so much. We appreciate you attending and supporting our webinars, and we look forward to seeing you at more. Have a great week.
Thanks,
Bye-bye.
Peggy.
Thank you.
Thanks for having us.
Thank you, Steve.